Okay, can you hear me? So please tell me whether you can hear me. Okay, thank you. So I will start the lecture now. So today, I've just finished a lesson for 4 hours in the afternoon. But no, don't worry. I'm still very energetic, right? So I think my record is teaching 9 hour, 3 hour in the morning, 3 hour in the afternoon, and 3 hour in the evening. Okay, so 7 hour is not something too bad. For this one is our third lesson. First of all, you are most encouraged to do pre-reading before the lecture, especially the PowerPoint or even the course menu. Okay? So please go through the materials to see whether you can understand the material by yourself. I think it will be much better. So you have done the pre-reading. Legal system is the foundation of your legal study. You usually low client will ask you any question on legal system. Okay? Usually your client will ask you a question about contract law, company law, etc. But it's the foundation of your legal study. You have a good foundation, you'll find legal study much more easier. You'll find it useful in studying all the law subject in the future. Right? Send email to me if you have any question. So I will finish the remaining part for this lesson. I will finish the remaining part of chapter 3. Please note that in the last lesson we have done we have made a silly mistake. But the recording. Yesterday I've done the recording, and so I've asked our colleague to upload the recording of the second session of last lesson to show. Right? And so in the second session of this lesson, I will finish chapter 4. Chapter 4 is a very short one, so we only need one session to finish chapter 4. It's about finding and citing sources of law. And now we go to chapter 3, the second part. So in the last part we have gone through the different sources of law. So in fact we are focusing on the literary sources and also legal sources. So in chapter 3 the main emphasis is on legal sources. So it means what are regarded as law. From time to time you come across a lot of regulation, for example school regulation. So it's not exactly law. So it's only school regulation. In the last lesson, we have learned the different meaning of common law. We know that in the year 1066, William the Conqueror unified England. So he extracted all the law common to the whole country. This is the reason why the law is called common law, because it's common to all parts of England. Now we go to the last meaning of common law. Is the meaning in a level sense. In the broad sense, it means law so common to all part of England. But is the level sense of the term common law is something in contrast with equity. Okay? The principle of law are developed through the common law court. So in the 12th century, we have the common law court. Okay? 普通法法庭. All the legal principle or the law developed through the common law court is called common law. But later on, the king has set up another court. The court was called equity court, 衡平法庭. Okay? So the equity court, they develop another set of case law. So it's in contrast with the old common law. Okay? So the old set of law was called the common law. The new set of case law was called equity. Of course, there will be impact of having two sets of case law. When we have both common law and equity, there will be complication. As long as we have two sets of rules, usually there must be some complication. So there will be conflict between common law and equity. So we have to know what will happen when common law is in conflict with equity. So it's a major concern in this chapter, and also it's quite difficult concept. Many students find it quite abstract, quite difficult to understand. So what I can do is to explain to you the difference, bit by bit, so that you can understand the concept more easily. First of all, when we come across the term equity, 衡平法, right? So try to understand the term equity. Please go to page 46 and do activity 2, page 46. Please go to page 46 and do the activity 2. Page 46. Page 46. So you have to consider the meaning of equity. Right. So the underline the description that most closely agree with what you think the verb equity means. You may select more than one item. Okay, 1, 2, 3, 5. I try to consider the meaning of equity. Which one is the meaning of the term equity? Okay, very good. I think all of you are very smart. You know the meaning of the term equity. So you're correct. All the 5 meaning are the meaning of equity. Fairness, okay? So it's the ordinary meaning of equity. Issue, share capital. Even though it's not the meaning we use in this chapter, so it's a very usual meaning of the term equity in company law. So whenever there's a company, the company will issue share. Those shares are called equity. And also we have the term equity joint venture, equity. Usually it means share. So number 3, impartial. What just what is right. All of them are the meaning of the term equity. So at the very beginning, so equity only means something righteous, something fair, something right. But later on, equity has developed its own meaning. Right? Equity. So in fact, it's a particular brand or principle and rules which is different from common law rules. The significance of equity is that it gives rise to claim to legal right. Of course, the historical background is that common law was developing in the 12th century. But usually for a system, it has a long history. What will happen? What will happen is that people will just follow something in the past. Okay. For example, if you work in a school which has a very long history, so usually they will stick to the tradition. Most people don't want to change. They just follow something in the past. Okay. So of course it will cause some problem. How did equity develop? Equity developed through person claiming right that were not recognized or enforced by the common law court. It's especially true for civil law. Because in civil law, if someone wants to take a legal action, there must be a cause of action. Okay? If the cause of action is not recognized by the law, you are not entitled to sue the other person. You are not entitled to enforce your right. For example, so if someone has signed a contract with you, he does not perform the contract, you can sue him for breaching the contract. Breaching the contract is some kind of cause of action. Okay? So it's something recognized by the court. So you can enforce a right by taking the case to the court. But if someone is only impolite to you, can you sue him? The answer is no. Okay? Because there's no such cause of action. Okay? So it's not something recognized by law. Impolite is not something recognized by the law. Okay? So if someone is impolite to you, usually you simply cannot sue him because the law, the court does not is not prepared to recognize or enforce this kind of right. So sometimes you use the term claimant. You use the letter C to represent claimant. A claimant is very similar to plaintiff. Is someone who requests a different kind of help or relief. So when you are suffering from some wrongs, you want the court to help you. So you are seeking relief from the court. The other party is called the defendant, right? For example, if you have a contract with the developer promised to build a house for you, so you will pay 12,000 in return, but now the developer does not give you the house, right? So you want my house, the developer say that, okay, maybe I will give you some money compensation, but you don't want any money back, you just want to have the house, okay? So it's the reason why you take the case to court because you want to get some relief. You want the court to enforce a right. You want the court to force the developer to build a house for you. So for common law and equity, in fact, they were two separate branches of law. So common law developed from 12th century in the common law court. All the law from the common law court was called common law. Okay? All the law from the equity court was called equity. But of course, you don't have to memorize those names. Common law court, we have King's Bench, Common Pleas, etc. So equity court, I think the most famous one is called Court of Chancery. The head was the chancellor. But what happened is that so in the 13th century, we can find a lot of defect of the common law, a lot of problem of common law. So later on, I will tell you the different defect of common law. Okay? So people was not so happy with the common law. Okay? They thought there were so many defects of common law. What did they do? They appealed to the king's senior advisor. So he was called the chancellor. He was a very senior minister. So in the government, he was a senior advisor to the king. So the king, at the request of the chancellor, set up another court. That's called Court of Equity. The major one was the Court of Chancery. So in the year of 1875, so there was fusion. Later I will tell you what's meant by fusion. Fusion means the common law court and also equity court merged together. So nowadays, all the court will use both common law and also equity in the hearing. So there's no longer any common law court or equity court. All the courts are the same. Before the year of 1875, so we have two separate courts, common law court and also equity court. But now all the courts are directed to use both common law and also equity. So it's just like Hong Kong, in the district court, in the magistrate, in the CFI, in CA, CFA, all of them will use common law and also equity. There won't be any common law court, there won't be any equity court. Equity, in fact, we call it a remedial jurisdiction,補救性. So it's remedial. So it means that equity was not to replace common law. Equity will coexist with common law. So now we all have both common law and also equity. But in proportion, equity was only a very small percentage to common law. Okay, so maybe I can give you some idea. For example, we can say that equity is only maybe 10% of common law. Okay, equity was only a very small portion in the case law. Okay, so why we call it remedial? Because there were defects in the common law. The people, those people, the British people, the chancellor, the king have realized there were some defect in the common law. So what did the king do? So instead of reforming the common law court, the king have set up another court. The king appointed the chancellor to set up another court. So the function is remedial. So equity was not intended to replace common law. Common law was kept by the king. Common law remained the same. Okay? There was still common law court. The judge will also conduct a hearing in the common law court. But the king set up another court. So it means that if you have dispute, you want to sue someone, you can choose either common law court or equity court. Is the choice open to the people. So it's the reason why you call it remedial. 補救性 okay. So the equity was not intended to replace common law. In fact, it only supplement. Common law. Just like the case. For example, if you have a full-time job, your salary is 15,000. You think, oh, the salary is too low. You want to have additional income. What would you do? You take up a part-time job. You do some part-time job in the evening. You earn 3,000. But your part-time job is not intended to replace your full-time job. Okay? You still have the full-time job. Why you take up the part-time job? Because you want to supplement. You want to have additional income. You want to supplement the full-time income. So totally, you will have 15,000 plus 3,000. So the total income will be 18,000. So it's the use of your part-time job. So when someone knows that you are taking a part-time job, some people think that you are going to use the part-time job to replace your full-time job. It's not the case. Why you take up the part-time job is simply because you want to have additional income. Why we have equity? So first of all, we have to know there were defects in the common law in the Middle Ages with example of equity response. To summarize, we can see that the problem of common law are as follows. The first one is limited remedy, unjust consequence, new rights, in particular, creation of trust. These are all the four major problems of common law. Now please do the 4 case study on page 48 to 51. So please go to page 48. Please go to page 48. Case study 1. The defendant, D stand for defendant. D promised to build the claimant. C stand for claimant. D promised to build C a house. D did not build the house. This is a breach of the contract. There should be a contract between D and C. So under the contract, D promised to build C a house. Now D did not build the house. What remedy will you give C and Y? Okay. If you imagine, now you were the judge. Okay. So the case is before you. You see that is very clearly, there's a breach of contract between C and D. So it means that D should be liable. So what remedy will you give C? Okay. So imagine now you are the judge. See what remedy? Remedy means what the court can award to the plaintiff. Okay. 司法報告 in Chinese 司法報告. Okay. So it means what the plaintiff can get from the court. Now you know that, so the D should be liable. But now the issue is what remedy the court should award to C. Now we may look at the slide. A common law remedy for tort and also conjugal are usually the usual remedy is damages. So under common law, the court will only award damages. Okay? Damages mean money compensation. But please note that damages is the legal term. Is the major remedy used in civil law, not only in conjugal law, but also in tort law, company law, intellectual property, nearly all the civil law will have damages. Okay, but the point is that some claimants do not want damages. For example, if you have signed a contract to buy a house from the developer, you like the house, you like the location, you like the environment, you don't want any compensation, you don't want any money. Of course, we have to realize that money is the most important, most useful, most convenient remedy, but it's not the only remedy. Some people they don't want money. Why? They want the house. They like the house. They like the location. They like the environment. They simply cannot find another house. So in Hong Kong, so it's not too common for the court to award, say, specific performance or some other remedy, but in foreign country, it's quite common because many houses are quite unique. You simply cannot find the same house. Okay? So of course, it's very different from Hong Kong. Because in Hong Kong, the apartments are more or less the same. Right? So they want the defendant to perform the contract. So for the claimant, when they went to the common law court, the common law court said that sorry, we cannot do any other thing. We will only award damages. Common law court, the judge in the common law court only awarded damages. The judge will not compel the defendant to perform the contract. Sometimes the plaintiff want the defendant not to do something, so it's called injunction. So in this case, so if you want the defendant to perform the contract, it's called specific performance. 強制履行定so it's a remedy under equity. So it's called equitable remedy. Specific performance of a contractual obligation. It means the court compel the defendant to perform his contractual promises. For example, under the contract, the developer had to build a house to the buyer. Now the court compel the developer to build the house for the buyer. Of course, there must be a contract between the party. Right? If there's no contract, usually the court will never compel anyone to do anything. So specific one is relating to a contract. There must be a contract. There must be a legally binding contract before the court will order specific performance. And then we go to injunction. Injunction, so usually we call it 禁制令. But please note that for injunction, we have two different types of injunction. The first one is more common, or much more common. Right? So it's called prohibitory injunction. Prohibitory injunction is that the court order the defendant not to do some wrongful conduct. For example, not to cause any noise in the morning, not to cause disturbance to the plaintiff, not to go to some area. Is called prohibitory. 禁制性 okay? But sometimes injunction is mandatory. So for our Chinese translation, usually we'll ignore the mandatory injunction. We just focus on prohibitory. So mandatory injunction is to compel the defendant to undo a wrongful act. For example, if the defendant have some illegal structure in his house. So there may be a mandatory injunction to compel the defendant to remove the illegal structure. Equitable remedy are always discretionary. What does it mean? It means that it's at the discretion of the court 酌情權由法庭酌情權去決定嘅。So we call it in the discretion of court, discretionary. But please note that when we say discretion, usually the court will exercise the discretion very carefully, and also they have a lot of rules. So for guiding the court to exercise the discretion. Don't think that is something arbitrary. So don't think that's arbitrary. Don't think that the court can choose whether to grant injunction or not. There are lots of rules to guide the behavior of the court. It means that the court has a choice whether to grant the remedy or not, even if the claimant prove his case. But usually the court will exercise the discretion very carefully and also rationally. There are lots of rules for the court to follow in exercising the discretion. Okay, so now please go to page 49. You see that so usually so it's discretionary. Of course, under some circumstances, the court will not grant discretion. The equitable remedy. For example, where damages will be an adequate remedy, where the claimant has waited too long to bring the proceeding for the remedy. Under such circumstances, the court will not grant any equitable remedy. Okay, now we go to the second example. The first one is quite easy. The second it will be more difficult. Okay. So now we go to do example. The second example. Please go to page 50. Page 50 of your workbook. Right? Unjust consequence at common law. The defendant looked after C, and 80-year-old man who is unable to see very well. D encouraged C to sell his house to D for a price that is well below its real value. For example, the real value of the house would be 5 million. Now the defendant asked C to sell the house to him at the price of 1 million. It's something well below its real value. Would you allow D to keep the house? Of course, when C had discovered that the price was well below its real value, so of course D would like to cancel the contract. Okay? So would you allow the defendant to keep the house? D may argue that he has followed all the legal rules in buying the house. Okay? So he has followed all the procedure, all the formality. He has signed all the documents required by law. Of course, C would like to recover the house, okay? But of course, D would simply refuse to do so. A maxim, so a maxim usually means a very famous statement. So Alice asked me, what does maxim? Maxim. So Usually it means a statement which is quite well long. Just like a quotation 好似一啲金句咁樣OK， of course it's related to equity so it's called equity maxim. So for this case, so common law look to the form of the transaction. Common law will prescribe all the procedure, all the document you have to sign before you get the interest of the house. The court will not generally go beyond the documentation. As long as the party have followed all the procedure, sign all the necessary document, he will get the interest. So it's the spirit of common law. Common law will say, sorry, we won't consider something beyond the documentation. So now D has already followed all the legal procedure. He has signed all the document. So he should get the interest of the house. But equity response. Equity would be willing to allow evidence to be produced of the circumstances surrounding the transaction. So the judge in equity would set aside. Set aside means to cancel the transaction on the ground of undue influence. Undue influence is something you will study in contract law. Undue influence is one of the vitiating factor of contract. Vitiating factor means damaging. Which is a factor which will damage the validity of the contract. So it's called undue. Undue, in fact, it means improper. 不正當影響OK。So undue means improper. Undue influence means improper influence. So for D, he exercised undue influence on C. Okay? So because he had a very close relationship with C, he looked after C, and C would rely on him to a very big extent. So when he exercised the undue influence, the transaction should be set aside. Okay, and now please go to the third, case study 3. Case study 3 now is more difficult. Case study 3. C gave his house to his good friend D using all the proper documentation to transfer title to the house to D. It means that C has already assigned the house to D. D already promised C that he would look after the house and transfer the house to C's son S on S 25th birthday. When S was only 19, D sold the house to X and used the purchase money to buy himself a new car. Okay? So now the registered owner is X. Okay? So previously the registered owner should be D. Okay? But now D has already sold the house to X. So who should own the house? Is it C, D, or X? So we have 3 parties involved. Of course, we ignore the son of C. So we have 3 parties involved: C, D, and also X. Each of them have been the owner of the house. C was the older one. He assigned the house to D. Now D assigned the house to X. So who should own the house? Of course, the dispute should be because C had discovered that D has already assigned the house to X. So he is the reason why he wanted to sue D or X to recover the house. So it's a triangular relationship. We have C, the original owner. He assigned the house to D, and D promised him he would assign the house to his son when his son was 25 years old. But now he has breached his promise. D has breached his promise, and he sold the house to X. Please note that in this case study 3, common law, there was no contract between C and D. It was not a contract, eh? No, for the promise to give the house to the son of C when he reached his 25th birthday. It was not a contract. We, of course, you may not quite understand why it's not a contract, but of course, you will know more when you study the contract law. No, please accept that the fact that there was no contract between C and D on this arrangement. Okay? Equity common law. So there was no contract, so C cannot sue D. Okay? C simply could not enforce his right under common law. Common law does not recognize this kind of arrangement. So the judge in common law court will say, no, Mr. C, why were you so foolish? Why did you assign the house to D? It's something so dangerous. Even though I believe in what you say, it's something so dangerous. It's not something recognized by law. The interest has already been assigned to D. Now D should be the owner. He should be in a position to assign the house to anyone he like. Okay, so we do not recognize your interest in the property. You have no interest in the property. The house was owned by D, and he assigned him, he sold the house to X. He was entitled to do so. But of course, I will cause unfairness. I will be unfair to C. It will be unfair to S. So equity recognized that D is the owner of law, but will award remedy to C. The remedy is for D to hold the legal title to the house on trust for D. If D has already sold the house to X, so of course D have to return the money to C. Okay? So X can still be the owner of the house. X will get the title of the house, but D have to return the money to C because he was only a trustee. Now we go to the fourth situation, the case number 4. Let us suppose that D did not buy a car, but nevertheless, if he used the money to buy a car, he had to either return the car to C or he had to sell the car and return the money to C. If D did not buy a car, but nevertheless spend all the purchase money, is now bankrupt and not worth suing. Please note that is the most usual situation. For the bad guy, either he would abscond. Abscond, it means that he will leave the country or leave Hong Kong. He will go to another place. No one can trace him. Or he has spent all the money. Even though you can locate him, but he does not have any more money. He has spent all the money. These are the two most usual situations. It means that C simply cannot recover any money from D. So in this case, the dispute will be between C and X. Okay? C will urge the court to declare that he's the owner of the house. X will say that so I have already paid the money. I should be the owner of the house. I should have acquired the interest because I have paid the purchase price for the house. For this situation, at common law, there's no legal relationship between X and C had no remedy at common law. So it means that under common law, X would get the title, C would have no remedy. Equity, the situation is not exactly the opposite. So in equity, the court has laid down a more reasonable legal rule. So it depends on whether X had knowledge of the trust. If X had knowledge of the trust, it means that he was in collusion. He was in collusion with C. He would have collusion with D. So if he had knowledge, so equity would be willing to order X to hold the house on trust for C. It means that X had to return the house to C. If there was no knowledge of the trust, in most cases, usually X, the purchaser, had no knowledge of the trust. X will be accepted as the sole owner of the house. It means that he will acquire the title of the house. If he had no knowledge of the trust. Because the law has to protect the outsider without knowledge. So please note that the law always try to strike a balance between different parties, of course. But again, the court has to set the rule. The rule is that it depends on whether X had knowledge of the trust. If X had knowledge of the trust, he have to hold the property on trust for C. He had to return the house to C, or he would say assign the house to anyone as directed by C. But now, if say if he have say low knowledge of the trust, he will be an innocent third party, so he should be protected because the law has to protect those bona fide purchaser in order to facilitate trading and also commercial activity. So now we can look at the so trust. Trust 信託必須trust is the invention of equity. Some people even say that trust is the biggest invention of equity. Trust, of course, trust is trust law. Trust law is a separate core subject in the LB program. So if you study, say LB, so there will be a subject or module called trust law. Trust law is a quite difficult subject. But trust, of course, everyone know that. So trust is very essential, especially for provident fund, MPF, and also other provident fund. Trust is something very essential because the money is held by the trustee. If there's no trust, there will be no MPF. The most typical relationship in a trust is that so there will be someone who set up the trust. He's called the settlor. So for example, if you set up the trust, you are the say you are the settlor. So you own the property originally, so you are called the beneficial owner. It means that legally speaking, you are not the registered owner, but you have the beneficial interest. So you are called the beneficial owner. Okay? But now you have assigned the property, for example, the share to the registered shareholder. So you ask your friend to hold the share for you. So your friend is the registered shareholder. He's only a trustee. He holds the share on trust for a beneficiary. Okay? So it's the most usual reason why we have to use a trust. Why you ask someone to hold the share for you. So one of the reasons is that you don't want other people to know that you are the beneficial owner of the share. Okay? It's something very common in the say investment field. Some people so they don't want other people to know that they are the beneficial owner of the share. They ask the friend or other relative to hold the share for him. Property is also the same. It's very common. Some people will ask other people to hold the property for him. There are so many reasons. So especially in England, many people who operate restaurant or takeaway, so he has earned a lot of money, but he does not report it to the tax authority. 去瞞即係避稅瞞稅係咪？So he always tell the government that he does not have any profit in the restaurant. But later he had a lot of money. He bought a house. If he bought the house, the government will conduct the investigation. The government will say, Mr. Chen, you always say that you have low income for your restaurant, but how come you have so much money to buy a new house? Hey? So Mr. Chen will find it difficult to explain. So it's the reason why when he decided to buy a house, he asked his friend, so Wong, to hold the house for him. So Wong is the trustee. The beneficiary may be the son of the settlor, or maybe the settlor himself. Sometimes he just want other people to hold the property, and he asks him to hold the property on trust for him. So the settlor may also be the beneficiary. In order to record the trust, sometimes the settlor will ask the trustee to sign a declaration of trust. Okay? To protect him. The settlor want to be protected. He asks the trustee to sign a declaration of trust. 信託契，sometimes it's called trust deed. Declaration of trust is only valid between the beneficial owner, settlor, and the trustee. So it's only enforceable between the two parties. It will not be enforceable against the outsider. The outsider has no knowledge of the trustee. Because he is on the face of it. This gentleman is the owner of the house. For the outsider, he only knows this gentleman. He does not know the identity of the beneficial owner. He had no idea of the existence of the beneficial owner. So the law has to protect the outsider. If the trustee sell the property to the third party, it will not affect the interest of the third party. He does not have constructive notice of the trust. In policy, declaration of trust is not recognized by law. So if you ask someone to hold the property for you, it's not something recognized by law. In China, the judge will say that we do not recognize this kind of say relationship. If the beneficial owner want to recover the money from the trustee, if it happened in mainland China, so he will not be successful. He will not be succeed in getting in recovering the money. So if you ask some people to hold the share of property for you, it's something at your own risk. Declaration of trust is unsafe and risky. Can you suggest the reason why people still use declaration of trust? There's simply so many reasons. Sometimes it's to save tax, sometimes to avoid the restrictions, sometimes it's to conceal the identity. So you don't want other people to know that you are the beneficial owner of luxurious flat. So you ask your friend to hold the flat because you does not want other people to know you are simply the owner of the flat. Basis of equitable intervention. The original basis for intervention was conscience. Equity acts on the conscience. So at the very beginning, so the judge in the equity court only used conscience. They did not follow the common law. Because when they set up the equity court, so they were not bound by any case in the past. They could exercise the discretion. They could make whatsoever decision they like. The decisions are based on conscience. They just use the conscience in making decisions. The chancellor was keeper of the king's conscience. What's meant by intervention or equitable intervention? Because equity has interfered with the legal position of common law. But problem of equity at the very beginning. So the judge in the equity court could use the conscience in making decision. But if you do not follow the case in the past, so different judges will have different decision. There will be inconsistency. Inconsistency means that the decisions are inconsistent with other decisions. So it will also cause uncertainty. Because if the case are inconsistent, how can you predict the outcome of the case? How can you understand the law? Because different judge will have different opinion, different decision. So it will cause uncertainty to the client. The judges in the equity court began to be consistent in the application of remedy. So they sit down and so they try to follow cases in the past. So they also develop the doctrine of precedent. So is the law, the principle of equity, they were as strictly defined as the common law. In order to achieve consistency, they will define the law very clearly. So all the judges in the equity court have to follow those precedents. In the year 1615, the English court declared that equity will prevail. What does it mean? It means that in the event of conflict in applying the two sets of law, that's common law and equity, the principle of equity should be applied. It means that we have to follow the principle of equity. I'll take a very simple example in your daily life. You will have mother and father in your family. Sometimes they will give conflicting instruction. The mother will tell you say you have to finish all your homework before you can fall asleep. The father say that no, Lodi, you may go to sleep. No, Lodi to be so no nervous. Okay. So if the father and mother give you conflicting instruction, the instruction are in conflict, which one should you follow? Usually, most people will follow the mom. They will follow the instruction of the mother. Okay, the principle. In common law and equity. If common law and equity are in conflict, we have to follow which one? The answer is which one should we follow? Should we follow common law or equity? Equity. Very good. Because equity was going to modify common law. If we still follow common law, equity will be used, will be meaningless. So it's the reason why we have to follow equity. It means that in the event of conflict in applying the two set of principles, the principle of equity should be applied. We call that the principle of equity shall prevail. Our principle is now expressed in legislation section 16, subsection 1 of the High Court Ordinance. Now we say that so the relationship between equity and equity is just one tree with two branches. Equity is no longer dependent on the view of the chancellor or the judges, but is a body of rules which is as complex as the common law. At the very beginning, the chancellor or the judges could make whatsoever decision they like, but now it's not the case. I don't think that the judge have very extensive discretion in making the decision. He have to follow cases in the past. Both rely upon both rely heavily on precedent in decision. Precedent, it means cases in the past. This is the reason why we have to study so many cases. Because when we come across a legal issue, we have to cite precedent to resolve our problem. So in 1873, all the courts were directed to use both common law and also equity. Now please go to do activity on page 53. Please go to page 53. Page 53. Just do question 1. For this one, you can see that also is very so it's something very similar to mortgage. Mortgage means that when you borrow money from the bank, you mortgage the property to the bank. You have to transfer the ownership of the house to D. That's the lender in return for the loan. Of course, it will be very sensible for the court to make an order to compel the defendant to reconvey the house to C. Because C has already paid up the loan. So the lender should uh, assign the interest back to the original owner. That's the borrower. And now we have a very minor one. It's called the Chinese customary law. It's different from the national law of China. Customary law sometimes it means it's called custom. In fact, it's the customary law used by Chinese before the British occupation in 1942. It means that in the late Qing dynasty, it's the custom used by local Chinese before the British occupation. In fact, is quite important. It's now only relevant in relation to dispute relating to land in legal territory. Even in the case of land, Chinese law and custom will only rarely apply. Because for those custom, they are not written down in any legislation. It will be quite difficult to prove the custom. Usually, you have to invite an elder, 長老, okay? So it's an elder in the village to act as an expert witness to say to explain the custom. No, of course, many elder they have already passed away, so it will be quite difficult for you to find someone to explain the custom. So customary law is not so no it's not something quite. It's not too common. It's not too common for the court to use customary law. For international law, of course, we know that Hong Kong always has signed so many international treaty 國際條約 for those international treaty please know that even though we have so many international treaty between Hong Kong and so many other countries, it's not a formal source of law. Because the international treaty will not be applied directly. Usually, it will be transformed into a local ordinance. So the ordinance is in fact is part of law of Hong Kong. It will be regarded as a legislation. So it means that international treaty will not be applied directly. Usually it will be transformed into an ordinance. Of course, we will for the ordinance. Of course, is a part of the law of Hong Kong. It must be promulgated or incorporated in Hong Kong. Now, please do the revision question. I'll give you 2 minutes time. Please do the revision question before we proceed to chapter 4. Well, texting it sounds like a pun. Of course, it is not the case. Usually, for those kind of arrangement, it's only for say personal property. For example, your watch, etc. But say for flat or property, usually we'll use either mortgage or legal charge 如果物業咧就係用按揭嘅就唔係用典當啊。So we'll go through the answer of the revision question very quickly, and then we'll proceed to chapter 4. Number 1, common law, in fact, it means case law as opposed to legislation. The essential feature of case law is the legal rules is inside the case. Okay, legislation is the law approved or enacted by the legislature. Usually, they are clearly stated in the legislation. For example, in the ordinance, we have section 1, section 2, section 3. All of them are legal rules. But they are written down very clearly. But for case law, you have to extract. So in chapter 5, we will learn how to extract the legal rules from the case. So number 2, common law also means principle of law developed through the common law court. The most important one, I think, is that for law developed through the common law court, it's called common law. For law developed by the cause of equity is called equity. Equity developed through person claiming right that were law recognized or enforced by the common law court. So it means that common law court could not satisfy the need of the people. And this is the reason why they petitioned to the king to set up another court. Purpose of equity was to replace common law. Of course, is false. Equity was not intended to replace common law. Number 5, the original basis for intervention should be conscience. True or false? Legislation is the only source of law in Hong Kong. Of course, it's false. Basic law is supreme over other sources of law in Hong Kong. The answer is yes. Meaning of common law. Law applied to the whole world. Of course, it's false. Law based on codes rather than on case. Of course, it's false. Case law as opposed to legislation is true. Common law court will grant specific performance of a contractual obligation. The answer is false. Because only equity will do so. Equitable remedy are always discretionary. The answer should be yes. Now we can just show you a very simple, say, no, we can use a case to illustrate the equitable interest. You have a short note on equitable interest. For equitable interest, the difference between a legal and equitable interest is that equity only enforces a trust against the trustee. That's the court asks the trustee to transfer the property to the beneficiary. If the trustee still keep the property or he still have the money, it will not be too difficult. Finally, equity enforce the trust against anyone. But the problem is that sometimes the trustee will assign the property, the interest of the property to an outsider. That's XP. So the problem, so now we have 3 different parties: owner, beneficiary, trustee, third party. Now the say the property.
Hello.
Sorry.
You're nothing's on screen.
Nothing on. Sorry.
Yes.
We are no.
Yeah.
I.
All right.
Oh, sorry.
Yeah, just letting you know because the chat
Yeah.
is
Yeah.
going
Yeah.
crazy.
Sorry.
All right, I'll turn my mic
Very
off.
sorry.
Sorry.
So it's the equitable interest. Sorry. Thank you for reminding me. Sometimes I will make some silly mistake. So you see that. So the most typical example is that the trustee assign the property, the interest of the property to a third party. Usually is a outsider. Okay. So whether the owner can recover the interest from the third party who get the property. So we'll use a case to illustrate so the situation. No, we have mentioned. So the issue is whether the purchaser, this one, so this guy, whether he has interest of the trust, he has notice of the trust. But people that a notice is, we have 2 possibility. Either it may be actual notice. Actual notice means that someone tell you actually. For example, if I'm meeting with you face to face, I tell you something. There's an actual notice. Or if I send a letter, a notice to you in writing, it's an actual notice. The other one is called constructive notice. Constructive is something more difficult to understand. So it means if the purchaser would have known it, if he had made all reasonably prudent inquiry. So it's something more difficult than actual. Most people know what's meant by actual knowledge, actual notice. But not so many people know what's meant by constructive notice or constructive knowledge, right? So we can use a very famous case called Wang Chim-ying. Wang Chim-ying and Chen Kum-wing. It was a 1990 case. Many people call it the minibus driver case. 小巴司機案。Because Mr. Chen Kum-wing, he was a minibus driver. So it's the reason why we call it minibus driver case. The significance of the case is that it illustrates how legal and equitable interests coexist in land. How the doctrine of notice work to determine the priority of interest. The facts were quite simple. Mr. Chen, he was a minibus driver. He was married. He had a wife. He bought a flat to live in using Mr. Chen's saving, but the flat was bought in the wife's sole name. It's something quite common in Hong Kong. Many people, they pay the money, but the flat was registered in his wife's name. 用老婆嘅名So Mr. Chen, so she was the registered owner of the property. But all the money was paid by Mr. Chen. Mr. Chen's wife then sold the flat to the plaintiff. That's Wang Chim-ying. So his wife sold the flat to the plaintiff Wang Chim-ying without telling Mr. Chen. Mr. Chen was not aware of the sale. Okay? The wife did not tell him why. You know why. Okay? So the reason because Mr. Chen's wife absconded. She took all the proceeds of the sale and left Hong Kong. So of course we assume that. So Mr. Chen's wife was not. The police could not trace Mr. Chen's wife. So many students will say you have to arrest her in order to get back all the money. But it was not possible because he had already left Hong Kong and the police was not able to locate her. So the plaintiff knew that Mr. Chen was living in the flat when she inspected the flat. When you inspected the flat, you should know there should be another occupant. Because when you inspect the wardrobe, you should know we have some clothing used by a man. Because the owner was a lady. There was a double bed in the bedroom. There was some thing used by a gentleman. So you should know there should be another occupant in the flat. The plaintiff did not get vacant possession of the flat when the transaction was completed. The difficulty in this case is that Mr. Chen's wife told Wang Chim-ying, we have already bought another flat, but the new flat was still under decoration. Please allow us to live in our flat for a few months before we deliver the vacant possession of the flat to you. 俾我住多幾個月先交攞俾你啦咁樣。But so he had already received all the money, all the purchase price. Okay? Then she took all the proceeds of the sale and left Hong Kong. Mr. Chen continued to live in the flat. One day, the plaintiff Wang Chim-ying visited the flat of Mr. Chen. Of course, Mr. Chen was very surprised to know that his wife has already sold the flat to some other people. The Wang Chim-ying asked Mr. Chen to leave, but of course Mr. Chen refused to leave the flat. So the plaintiff Wang Chim-ying sought possession of the flat against Mr. Chen by taking a legal action. So now we have two innocent parties. Please look there. The police is not able to arrest the wife of Chen Kum-wing. The wife has already left Hong Kong with all the money. Okay. now we have two innocent persons. Wang Chimying has already paid the money. And also Chen Kunming, so he paid the money at the very beginning. Now the wife has already taken away all the money. Okay. So which one do you think should be the owner of the flat? Do you think the court will order the flat to which one? Chen Kunming or Wang Chimying? Who will get the flat? Wang Chimying or Chen Kunming? Wang Chimying? Some people say Wang Chimying. You're sympathetic with Wang Chimying. Most students are sympathetic with Wang Chimying. Because many students think that Wang Chimying was not aware of the trust. Of course, it's something very dangerous. If you buy a flat and you ask your wife to be the registered owner of the flat, it's something very dangerous. The opposite is also the same. If a woman use the money, pay the money, and ask his husband to be the owner of the flat, it's also something quite dangerous. Most students are sympathetic with Wang Chimying. Most students think that Wang Chimying should get the title of the flat. We have two innocent parties who should get the flat. To your surprise. The issue is whether the plaintiff was a bona fide purchaser for value of the legal estate without notice of Mr. Chen's equitable interest. Mr. Chen, even though he was not the registered owner, he had interest in the flat. It's called equitable interest. Why is called equitable interest? Because the interest is only recognized by equity. Okay, so it's the reason why it's called equitable interest. The court held that as Mr. Chen had paid the whole or part of the purchase price, he had an equitable interest in the flat. The plaintiff had bought a legal interest which had been conveyed to her with the necessary formality, and she had paid for the interest. So it's for value. However, she should have constructive notice. The notice was not actual notice. Wang Chimying did not have actual notice of Mr. Chen's interest, but she should have constructive notice. It means that he have made reasonable inquiry. He should know another person was having interest in the flat. Okay, he had to make sure that the other party have also agreed to sell the interest of the flat to her. Okay, because he was in occupation of the flat, he should know there was another occupant in the flat. He should make proper inquiry. Okay? Therefore, Mr. Chen had priority. So at the end of the day, Mr. Chen will get the property. Okay? Even though the decision may not be understood by most ordinary people. So Wang Chimying, of course, she was very innocent. So she was in a very bad position. She had paid the money, but she could not get any interest. We have so many traps in property transaction. So you have to be very careful if you want to buy a flat. Now please take a break. Please take a break for 10 minutes. Again, so you are a bit confused. The issue is whether Wang Chimying had any notice of the trust. Of course, we have mentioned before, notice is classified into actual notice or constructive notice. Wang Chimying did not have actual notice. Okay? Of course, Wang Chimying would argue that she did not have any notice of the trust. Of course, she did not have any actual notice, but she should have constructive notice of the trust. Also, one of the very different things is that when the transaction was completed, Wang Chimying did not get the vacant possession. She allowed the wife of Chen to occupy the flat. Of course, it's something very dangerous. So if you cannot use it in completion, the purchaser will get the vacant possession of the flat before he pay all the money to the vendor 通常咧就係要得到嗰、個係交吉嘅通常要交吉嘅樓宇先至可以完成嘅OK the completion will take place when vacant possession is delivered to the purchaser. For case 4 so no, I think for case 4 we do not consider the difference between actual notice and say constructive notice. This case is quite complicated because it's not actual notice, it's constructive notice. Okay, I think now please take a break for 10 minutes. So it's built. Sorry. So I think don't worry. So after the case of Wang Qingying, in all the sale and purchase agreement, all the provisional agreement, so it's a clause for the vendor. He has to declare that no one has any beneficial interest in the property. If there's any beneficial interest in the property, everyone agree to assign the interest to the purchaser. This problem has been solved nowadays because the say the government or the say no the estate agent, they have already added a new clause in the provisional agreement. Of course, Wong was very unlucky. So he had paid the money, but he could not get the property at the end of the day. So Wong Miu Yu said it's not equity. But please know that is something very common. Sometimes we have two innocent party. Okay. For example, if someone has stolen the goods of another person, he sell the goods to a purchaser. So who should get the property? Okay. So the court is in a difficult position. If you say if you make a decision to say that the original owner should get the property, it will be unfair to the purchaser. If you make an order to say that the purchaser will get the property, the original owner would be very unlucky. So no matter what decision the court has made, someone will be very innocent. Okay. Of course, they can always sue the wife of Chen Kambing, but usually it's not possible. For many bad guys, usually they make the planning well beforehand. After they have got the money, either they will abscond or they will spend all the money. And now we go to chapter 4. Chapter 4 is about before we start chapter 4, so I would like you to go through a look prepared by me to explain the reason for equity. Also, first of all, so common law has some defect. People were not so happy with the common law court. They petition to the king. Or they petition to the chancellor petition to the king. If you were the king, people are not so happy with common law court, what would you do? Okay, so you have so many options. Either you may reform the common law court, or you may tell the judge in the common law court to make better decision. You ask the judge to attend a meeting. They tell the judge. So people are not so happy with you. They have so many complaints. You better make better decision. He may ask those conservative judges to retire early and replace them by more liberal judges. Okay? For judges, they were so conservative. They did not want to change. So no, you should ask him, you should fire him, just ask him to retire early. Okay? Or put them into prison. Because it's something so extreme. So no, which one would you choose? A, B, C, D. Which one will you choose? The answer is that the king choose neither one. Okay? Neither one is his choice. Okay? So he did not choose either of these options. Okay? Imagine that you are the boss of a factory. The factory only have one canteen. The canteen only supply Chinese food. The worker want other variety. What should you do? So you ask the chef of the canteen to prepare Japanese food. The worker want Japanese food. Should you ask the chef of the canteen to prepare Japanese food? The chef say that I've been cooking Chinese food for 30 years. I don't know how to prepare Japanese food. Would it be meaningful for you to force the chef to prepare Japanese food? What should you do? Very simple. Just set up another canteen to supply Japanese food, Thai food, and Malaysian food. No need to disturb the Chinese canteen. Just keep the Chinese canteen. They can continue to prepare Chinese food. You should set up another canteen to supply other variety. Okay? The king is also the same. The king of England, instead of reforming the common law court, set up another court. That's the equity court. All the law from the equity court is called equity. So for the Plaintiff, he want to sue someone, he has two choices. He can choose either the equity court or common law court. Usually the lawyer will advise him. The lawyer will say, you better go to the equity court. Because the equity court will give you more protection. The equity court will give you a more favorable decision. Okay? So it's the development of the equity court. In fact, it's only another choice open to the litigant. So the term in level sense or broad sense, when someone tell you that he's living in Hong Kong, what does it mean? The level sense is Hong Kong Island. The broad sense is Hong Kong, Kowloon, and also New Territory. So the term Hong Kong has two different meanings. Just like common law. The broad sense common law in the broad sense, it means the laws used by in England. Okay? So in the level sense, it means the common law developed by the common law court. Now we go to chapter 4. Chapter 4, finding and citing sources of law. After we know what are regarded as law, so we have studied the legal sources of law. Now we go to find the law. Okay? So for finding the law, we will focus on online resources. We have it has two advantages. The first one is convenient and also is free of charge. Nowadays, so once you have some students ask me whether any equity court in Hong Kong. Please note that there's no longer any equity court. So in Hong Kong, we don't have any equity court because in the year 1875, all the courts are directed to use both common law and equity. Okay? So we don't have any equity court. All the court will use both common law and also equity. But of course, when common law and equity are in conflict, common law equity will prevail. The court will follow equity instead of common law. So first of all, you have to distinguish literary and secondary sources of law. Literary source of law sometimes it means primary sources of law. It's the law in its raw state. It's the most authentic formulation of rules of law. It should be cited wherever possible. For the lawyer, when they appear in the court, usually they have to cite primary sources of law. They cannot cite a lecture law, they cannot cite a textbook. Usually they have to cite the legislation or cases. So they have to copy legislation or case when they appear before the court. It simply means legislation and also case law. Legislation, first of all, we start with legislation. Legislation in Hong Kong is called the laws of Hong Kong. So, of course, the term is a little bit misleading. It only means the legislation in Hong Kong. It does not include the case law. The hard copy is called Hong Kong Statute Book. Okay? The hard copy can be purchased from the government. Soft copy is available in the website of the government's Hong Kong e-legislation. That's the www.elegislation.gov.hk. Sorry. Later I will for legislation. I think it's something quite simple. You may just go to the website of e-legislation. Okay. So no, if you want to search legislation, you just go to the index. Okay. For example, so you can find chapter 1 is the interpretation and general clauses ordinance. So it's the format of the legislation. This one is the long title. This one is called the long title. Usually is the purpose of the legislation. This one is the short title. Second one is the short title. Is the name of the ordinance. interpretation and general clauses ordinance. And also where you're living is that so in Hong Kong all the legislation have chapter number. So it's chapter 1. So chapter number is quite useful. If you know the chapter number, you can find the legislation much more easily. Okay. So these are the different sections of the legislation. Usually either section 2 or section 3 is the interpretation section. So usually in the section there will be a lot of definition. Okay? So many terms are defined in this section. Sometimes in section 2, sometimes it's in section 3. Most ordinance the interpretation section is in section 2. But this ordinance is in section 3. For the literary sources of law, we have two major series of law report. Of course, you cannot expect all the hearing will have judgment. So especially for very minor case like littering, like spitting, usually there is low judgment. In the Mac Court, usually there's low judgment. In the small claim tribunal, usually there's low judgment because the cases are very, very petty, very simple. It will be meaningless for the judge to prepare the judgment because you have to know that to prepare judgment. So it's sometimes quite time consuming. The judge has to spend a lot of time in preparing the judgment. So for some very minor case, very routine case, there's low judgment. But from district court onward, so district court, high court, usually there will be judgment for all the cases. And for more important cases, they will be included in the law report. For the law report, only I think 20 to 30 cases will be included in the law report each year. The number is very small. Why cases are chosen? Usually because they have some very special legal principle, a very important legal principle. Okay, this is the criteria for cases to be chosen in the law report. Not because of the seriousness of the crime, not because so how much money is involved. It's not the criteria. The criteria usually is on the legal principle. For example, the case of Wang Chunying, it was included in the law report because it had very special, very important legal principle involved. Okay? So before 1996, it was called HKLR. In fact, it's also the Hong Kong law report. When I was a student, Hong Kong only have one set of law report. That's the Hong Kong law report. The Hong Kong law report usually it was prepared by the judges in Hong Kong. But after 1997, so it was prepared by Lexis. Lexis is a commercial publisher. So it's something quite different from the practice in the past. Another one is Hong Kong cases. It's also prepared by Lexis. So nowadays, if you want to have access to those law reports, you have to pay some subscription. It means that you have to pay money. Apart from primary source, so secondary source is also useful. There are some commentary on the law. Usually, they are more systematic, like contract law textbook, tort law textbook. They are written in a more systematic way. So you can trace the law, you can find the law, you can locate the law more easily. Okay. So usually they cannot be relied upon in the court, but they are useful for reference and study. Now we will do some exercise. So for finding record of judicial decision, we call those cases not included in the law report to be unreported judgment. So there are judgment, but those judgments are not included in the law report. In the past, you could only go to the law library of the Supreme Court to find those unreported judgments. But nowadays, it would be much more convenient. You can go to the website of the judiciary, you can find the judgment. Right? First of all, you have to be familiar with the court structure before you can do research on judgment. First of all, please go to page 84 and page 120 of the workbook. Is a charge on the cost of Hong Kong. The highest one should be CFA, and then CA, and then CFI, District Court, MacCon, many tribunal like Liens Tribunal, Small Claim Tribunal, Labor Tribunal, Obscene Article Tribunal. Right? This is a very rough chart for the structure of Hong Kong court. You can see so many levels of court. Even though, despite the fact Hong Kong is only a very small city in terms of area, but we have the full court system of UK. In fact, we copy the system of UK, the court system in UK. Okay? Because in UK also, unless you are in London, if you live in Manchester, if you live in Birmingham, you cannot find the High Court. You only have the this court in UK. They are called county court. And then we go to 120, page 120. So it's the route of appeal. So when someone lose in the magistracy, he could appeal to CFI, and if he lose again, he can further appeal to CA and then CFA. So it means that from cases starting from the lower court, it can be heard for 4 times. 1, 2, 3, and 4. 1, 2, 3, and 4. Right? But if the case starts from the district court, so it could only be heard for 3 times. So you know that in China, so they only allow 1 appeal. So if someone loses in a court, he can only further appeal. He can only appeal to the higher one. So there won't be any more appeal in China, in mainland China. Okay, so please memorize the name of the court. CFA, CA, CFI, and also district court, okay, magistracy, tribunal, etc. So now here we are going to do activity 1 on page 58. Okay, case type list. Please go to page 58 of the workbook. Page 58. The first activity is called case type list. Okay. Okay, so we can go to the website of the judiciary. This is the website of the judiciary. Okay, so you can choose judgment and legal resources, judgment and ruling, and then judgment. You click this one. You click judgment. So now you can see this page. So your job is to click on K type list. For example, FACV. What can you find? Like this one, a case type list. You can find this table. So FACV stand for File Appeal Civil, FACC stand for File Appeal Criminal, FAMV stand for Miscellaneous Proceedings Civil, FAMC stand for Miscellaneous Proceeding Criminal. No need to memorize this term. Okay? So if you are working in the law firm or as a litigation clerk or litigation lawyer, you will be very familiar with those terms. But as a law student, no need to memorize. Okay? I just want to show you. So we have different types of case. So Court of Final Appeal, we have 5 different types of cases. So we subdivided into criminal and also civil, final appeal, and also miscellaneous proceeding. MP miscellaneous proceeding 雜項案件。So and now we go to another one. We go to another page. So we go to now we go to the first case. We are going to study. So the first one is FACC 7 of 2005. Right? So our job is to find this case and answer question from A to I. Okay? So it's a case in the Court of Final Appeal. So if you know the case number, okay, so you can find the case very easily. After you have typed the case number, you click go. You can find this case FACC 7 of 2005. Yang Xiu Kang and HKSAR. You click this one. You can find the judgment. So after you have read the judgment, you have to answer those questions. If you have a hard copy, you can look at the hard copy page saying it should be 59. So you can just answer the question. First of all, in what court was the case decided? What court? What's the name of the court? It should be the Court of Final Appeal, CFA. It's a CFA case. Which type of case was it? Is it criminal or civil? It should be a criminal case, right? Who were the party? It should be Mr. Yang Xiu Kang, HKSAR. Okay. How were the party described? Yang Xiu Kang was described as the appellant, 上訴人 okay. HKSAR was described as the respondent, 對造人。So what was the composition of the court? How many? So no, it was the composition of the court. So how many judges are there? How many judges can you find? You can find number 1, number 2, number 3, number 4, and also number 5. Altogether, we have 5 judges. Okay? So who was? How were the member of the court described? Justice Lee, Chief Justice, 首席大法官。Another one is called PJ, Permanent Justice, 常任法官。MPJ, Non-Permanent Justice, 非常任大法官。What was the day of the hearing? Day of hearing, 16 February 2006. What was the day of the judgment? 13 March 2006. So usually the judge have to take some time to prepare the judgment, just like your assignment. Please note that there is no deadline. So the judge is only required to prepare the judgment within a reasonable time. Sometimes the judge will find it difficult to prepare the judgment. Why? Because the judgment is open to the public. So the pressure is very heavy. Okay? So you make some silly mistake, you make some silly argument, you may be laughed at by so many people. So if you write your assignment, only the lecturer will know your assignment. Usually it's confidential. It will not be open to the public. But for the judgment, it will be open to the public. everyone can have access to the judgment. Okay, so in general, what was the case about? It was an appeal case. Mr. Yang was convicted at the very beginning. He appealed to the court of final appeal. And also trying to. My question is, do you think the job of a judge in CFA, do you think the job is difficult or easy? As a judge in the CFA, do you think the job is difficult or easy? Difficult or easy? Very difficult. 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 Most students will give the same answer. Most students will think that the job of the judges in the CFA is difficult. But no, you may change your mind. I'm gonna show you the relevant paragraph. When you go to the bottom, what's the job of the judge? What did they do? Justice Bookery, I agree with the judgment of the Chief Justice. Justice Chen, I agree with the judgment of the Chief Justice. Justice Wybero, I agree with the judgment of the Chief Justice. Sir Ivor Richardson, I agree with the judgment of the Chief Justice. Do you think you can do the job? Do you think you can do the job? Very easy. Yeah, very easy. Okay. In fact, everyone can do the job. I can also do the job. I can be a judge in the CFA. Why we have such funny situation? Because it's the practice. When you're reading the judgment in Hong Kong, it's the practice. The judgment is written by a single judge. Of course, they will have discussion. Usually, so they will have discussion. They will try to reach a consensus. It means that they will try to make a unanimous decision. The court unanimously 一致性Chief Justice Lee said that the court unanimously allowed the appeal. Okay, it means that there's no difference among the judges. Usually they will try the very best to reach to reach a unanimous decision. Of course, there will be some exception. Sometimes a judge will reserve his decision. He will be opposing to the decision at the end of the day. But usually they try to reach a unanimous decision. And the judgment will be delivered by a single judge. Next time it will be the turn of Justice Bookery. I don't think that the four judges do not have to do anything. Sometimes it's the other judge turn. So just like a group presentation. So I think everyone should have some experience of group presentation. Usually, all the members of the group will present the project. They will have division of labor. But in the court, in order to avoid some complication or some confusion, is the tradition of the Hong Kong court. So the judgment will be delivered by a single judge. By doing so, so it will be easier. So if you are reading some English case, judgment are delivered by two judges or three judges. Sometimes there may be some complication. So of course, I like this style. Because reading judgment is easier if the judgment is delivered by just a single judge. But don't think that other judges do not have to do anything. And also, that appeal is not retrial. Many people have the wrong understanding. For appeal, sometimes it only lasts for 1 day or even half day or even just 1 hour or even just a few minutes. Okay? Appeal. So the appeal court will only consider the grounds of appeal. It's not a retrial. Retrial is something very uncommon. I don't think that's easy. Many first trial has taken many trials have lasted for several months. How can you conduct a retrial? Okay? Because a trial is so time consuming, especially it will be very unfair for the defendant, the victim, the witness, etc. So the court has to ask the witness to come again. It is something very difficult. So usually, so the so-called appeal is only so the appeal court will only consider the grounds of appeal 上訴理由and also sometimes the appellant only appeal on sometimes they will appeal on conviction, sometimes they will appeal on sentencing so the appeal court will only consider the grounds of appeal the appeal court will not say conduct the trial again. I don't think that the high court will consider the case again. It's not the case because when they only consider the ground of appeal so they just rely on the paper usually the appellant so the respondent, the witness, they don't have to appear in the court in the appeal 甚至係唔需要出庭嘅咁喺上訴嗰陣時Okay, so in the appeal the party to the litigation simply do not have to appear in the court they just instruct the lawyer to do all the job. There won't be any more say cross examination, etc. So the appeal court will only consider the grounds of appeal. For example, if the sentence is excessive. So for example, when the defendant was sentenced to 10 years of imprisonment, he will appeal on the ground that the sentence is excessive. The appeal court may reduce the sentencing from 10 years to 6 years. This is what the appeal court will do. We can do another one. So another one is HCMC 6 of 2007. You can find that is high court case HCMC. So the case we can repeat the question. First of all, in what court was the case decided? I should be the high court. Court of first instance. High court is divided into CA and also CFI. Together they are called high court. Okay? So the second one, what type of case? Is matrimonial causes. Matrimonial means family. The most usual category is divorce. So even though family case may not necessarily be divorce, but most of them are related to divorce. 離婚 right? So how were the party? Who were the party? So it should be B and A. So that in this case, the identity of the party must be concealed. It will not be disclosed to the public in order to protect the privacy. So how were they described? B was described as the petitioner. A was described as the respondent. So that in different legal proceeding, we use different terms. We do not use the term plaintiff, defendant. We use the term petitioner. 呈請人 Okay. So it's the name of the legal document. So when someone wants to divorce, he has to file a petition to the court. Okay? So what was the composition of the court? So we find we only have one judge. So how was the member of the court described? He was described as Justice Hartman, the Honorable Justice Hartman. 夏正民大法官he has already retired. So what was the day of hearing? 15 August. Day of handing down judgment, 20 of August. What does it mean? It means that Justice Hartman was very efficient. He only took 5 days to finish the judgment. So what was the case about? It was a divorce case. So we go to next one. The last one. DCMP 544 of 2008. You find the format is a little bit different. In what cause was the case decided? It should be district court. What type of case? It should be miscellaneous proceeding. 雜項案件啦 something miscellaneous, it cannot be classified so easy. It's called miscellaneous proceeding. Who were the party? So we have three party, Tai Yao alias Tai Chi Yu, Wang Fengling, and also Li Shuk. Okay, so how were the party described? Plaintiff or defendant, right? So what was the composition of the court? We only have one judge, Her Honor Judge. It means that the judge was a lady. Okay? Her Honor Judge Mimi Chen. Day of hearing 14th of July. Day of handing down September. 1st of September. It means that the judge might not be so efficient. He should take say more 1.5 months to finish the judgment, right? Also, you can find this one, alias. I don't know what it means. It means that he has another name. So some people have another name. So if you want to have a new name, sometimes it will cause you inconvenience. For example, if you are called Chen Yuming, so you want to be called Chen Xing, you have to mention your old name from time to time. Okay? It's called alias. Yao Ming. So it means that another name is Tai Chi Yu. Sometimes it's quite difficult, quite inconvenient. So I don't think that is a very good idea for you to change your name. It will also cause you some inconvenience. Also, can you please look at this one? I try to see whether you can understand this paragraph. Can anyone understand this paragraph? Jiang Kanfei, so can you say that you agree with me? Of course, it's not possible. No, I don't think that don't think that the judge will agree with the chief justice. Sometimes the judgment is delivered by a permanent judge, especially for burglary. You can find a case maybe in chapter 6. You can find a case the judgment was delivered by Justice Burglary. I don't think that the chief justice will always deliver the judgment. So sometimes it's Justice Chen, sometimes Justice Burglary. I don't think that the chief justice will do all the job. Piece of land also is a legal description of a piece of land. Okay. Agreement data so and so for purchasing or property loan as so and so is the legal description. Piece of that. This one is the legal description. In fact, the most usual description we call it address. Usually it's very simple. Kings Road, 997 Kings Road. There's a building called Wiley Building. So it's flat number 15 on the 10th floor of Wiley Building. This is the most common format of address we use in our daily life. But in law, you cannot just use this address. In law, you have to identify the lot involved. In Hong Kong, all the land are divided into lot. For example, so some are called Quarry Bay Marine Lot. Okay. So this one is called Quarry Bay Marine Lot. But the building does not occupy the whole Quarry Bay Marine Lot. So we have Marine Lot number 1 is subdivided into different sections and then different subsection and further into different sections. Okay. So it's a legal description. So if you are doing conveyancing, you will know the description of the lot 呢個地段 okay. So sometimes so we have different laws in Hong Kong. So you have to give a legal description of the lot. And then Can you get what is meant by 1/1335 part or share? So what does it mean? 喺香港if you buy a flat, you are buying the interest you buy is called undivided share. For example, the building has 1/1335 share. 有1335個不可分割嘅部分So if you buy a flat, you will have one share. Okay? So altogether, the building has 1/335 undivided share. So when you buy a flat, you only have one share. Okay? So it's the interest you have acquired when you buy a flat. So many people, when they buy the flat, they do not know what they have already bought. So you have, of course, you learn more when you study conveyancing. So for the thing for the advanced search, it may not be so efficient. Usually for the website of the government, usually they are not so efficient for searching purpose. For simple search is good. But for more advanced search, it may be more difficult. For example, you can click the advanced search. You type 兩角空. You can how many cases you can find? You can find so many cases. If you type the name you can find so many cases. So you better so in page 61. So we advise you to type 兩角空 versus HKSAR. You type 兩角空 versus HKSAR. The number will be much smaller. But you can get 874 cases. You will find so many cases involve Mr. Leung Kok Hong. We'll skip most of the content and then we'll go to page, I think, 66. Understanding headlock. So the major difference between reported case and unreported case. The principal difference between an unreported case and reported judgment is the headlock added to the judgment by the publisher of the report. So if a case is unreported, you only have the judgment. I think all of you have seen some judgment. For example, this one is judgment. There's no headlock. So you can only have the judgment. So usually you have to go through the whole judgment before you can understand the case. Sometimes for many lawyers, they think that is very time consuming. If they have to go through the whole case, it's very time consuming. Some judgment is very, very lengthy. It may be more than 100 pages. If you have to go through the 100 pages, it's something so time consuming. Right? So it's the reason why for reported case, there will be an editor. Okay, 編輯. The editor usually he must be a legal practitioner. Sometimes he's a judge. Sometimes he's a barrister at law. The editor of the law report will prepare a headlock. Okay, so I can give you a example of headlock. This one is an example of headlock. The case is called 赖寬容. Okay? So it's a headlock. You can find different part of the headlock. Right? This one is a headlock. A headlock is, in fact, is something like a summary. So it's a very old English term. In fact, it means summary. It's a summary of the case. The case may be 30 pages, 20 pages, or 10 pages. But for the headlock, you can save a lot of time. The headlock usually is only 1 or 2 pages. So you can save a lot of time. These are the different part of the hello. So you have the name of the party, Miss Lai Fun Yong. She sued the employer, the Tin Sung Valley Public Primary School. The case was heard in the High Court. It was the reference number of the case, the name of the judge, Justice Hunter. So the day of the hearing, 1st of July 1985. This one is especially important. This one, this line is called catchword. Okay? So again, in the say in the okay, so now in the workbook, so you have to you can find the term. Okay? So there's a headlock. So the principal difference between an unreported and a reported judgment is the headlock added to the judgment by the publisher of the report. So the headlock, of course, is convenient. So it will save your time. If you say if you have interest in the headlock, if you have interest in the case, you can just go through the headlock. You can save a lot of time. You only have to spend several minutes in reading the headlock. So that you have a rough idea of what the case is about. Before we consider the value of headlock, we must state clearly that headlock is not the law. Headlock is for the convenience of the lawyer or law student. Some law students are very lazy. They just rely on the headlock. But the headlock is not 100% authentic. It's not 100% reliable. The warning is extremely important. Headlock must never be relied upon as accurately stating the law. Headlocks are prepared by editor. They are not prepared by the judge. Okay? For example, the judgment was prepared by Justice Chen, but the headlock was only prepared by the editor instead of the judge who hear the case. And not by judges. While it's true, as we have already mentioned, that judges approve the headlock in authorized law report. This does not mean that the headlock is substitute for the judgment itself. You must always check the judgment to see if the headlock accurately state the law. So one of the important part is called the catchword. Catchword is sometimes called keyword or phrases. So we can find our example. This one is the catchword or keyword. So the significance is that you will have a very rough idea of what this case is about. The case is about employment. So the specific issue is about damages for wrongful dismissal. It means that the claimant or the applicant, he was dismissed by the respondent or defendant wrongfully. Wrongful dismissal 無理解僱 okay? So no, she wanted to recover damages for the wrongful dismissal, right? So if you are practicing on this field, you may have interest in this case. For example, if you think that you have low interest, you are not specializing in employment cases, you can just skip the case. So it's the function of the catchword. So it gives, say, for the lawyer, for many lawyers, especially for barristers, they have to go through all the new cases in the month. Right? Usually they have to spend the whole morning in the Saturday to go through all the new cases. It's very important. If they are not aware of a new case, so they will be criticized very heavily by the judge. So if you cite a case which has already been overruled, you will be in serious trouble. So it's the reason why the judges, why the lawyer, they have to spend a lot of time in reading new case. But of course, So for lawyer, they have different specialization. Some lawyer are specializing in conveyancing, some lawyer are specializing in employment, some are specializing in civil litigation, some are specializing in criminal prosecution. So if this case is not within the specialization, they may skip this case. But if this case is within the specialization, of course, they will go further to understand this case. So it's the function of the cash flow. And also this one is the fact of the case. This one is the facts of case. This one is the decision of case. Decision of case, and also this is the final outcome. When Miss Lai Fun Yong appealed to the court, the appeal was dismissed by the court. It was the final outcome. You can find of course, you want to know the reason, you have to go to the full case. But this one, held. Okay, held is the past tense of hold. Okay, so usually the judge will make the holding. So usually we use the past tense. It means that it was held that. It was held that. Okay, the provision of full-year probationary period in the condition of service did not convert the contract for 1 year into a contract for 2 years. Despite the fact that the probationary period was 2 years, the contract was still a 1 year contract instead of a 2 year contract. So the compensation should only be 1 month's salary. It means that Ms. Lai could only recover 1 month's salary instead of 2 months' salary, because the contract was only a 1 year contract, and she was only required to serve a 1 month notice to terminate the contract. So she could only get 1 month's salary. Okay, the dispute is on the amount of compensation or damages which can be recovered by the Miss Lai. But of course, you will be very surprised how come Miss Lai would appeal to the High Court. Because I think when the case was in the mid-80s, the salary of a primary school teacher, I think it should be several thousand. The amount in dispute was only several $1,000s. Okay? But the legal cost will be much bigger than the salary. Okay. So the salary was only several thousand, but the legal cost, you can see there was a counsel, there was a lawyer, SC Siu instructed by W.I. Zhang. W.I. Zhang is the law firm, name of law firm. This one is the name of the barrister. And also cases cited in the judgment. So no, it was very surprising to know that she brought the case to the High Court. Because the legal costs involved would be very substantial, despite the fact that the amount in dispute was only several $1,000s. So it's an example of a headlock. But sometimes the difficulty is that sometimes you may not quite understand the case by just reading the headlock. Sometimes it is simply too precise. Okay? So you don't have enough detail, so you will have difficulty in understanding the case. So this one is the appeal. For this case, the fact was not in dispute. The issue was on the legal side. From time to time, we have to know that for many legal action, we have dispute of fact and also dispute in law. Okay. So when you are when you are studying the case, when you are studying law at this stage, usually you are studying the dispute in law instead of dispute of fact. A summary of the relevant fact. Please note that the court will make a finding of the fact. Although these are the facts shifted by the legal process. So usually there will be documents submitted in civil case. In criminal case, there will be investigation by the police or other law enforcement agency. But in civil case, usually we have documents submitted by both sides, submitted by either the plaintiff or the defendant. So there are when you proceed to say module 2, you learn more. So if you want to sue someone, you have to file a statement of claim. The other party will file the defense. So from those documents, so you can find out the fact. In some case, there was no dispute of fact. In many cases, especially in civil case, because we have lots of documents, usually there may not be any dispute of fact. The dispute was only on the law. Okay? So in this case, in the case of Lai Fun Yong, you cannot see any dispute of fact. The dispute was only on law. In most cases, they are likely to be very different from the fact as they appear to the solicitor handling the case. If you are a solicitor, so the story told by your client may not be true. Okay? So sometimes the version he told you may not be so true. Okay? So at the end of the day, the court will prepare a set of facts which are believed by the court to be true. So the first one is summary of the decision of the court, and also the principle of law applied by the court in coming to the decision. Of course, it will be something very, simplified. So if you want to know the detail, you have to refer to the judgment. However, remember that the holding, as stated in the headlock, must be checked by reading the judgment of the court. So we will know more in Chapter 5. In Chapter 5, we will study more about case law. For those other search, I think for the first exercise, it will be something quite easy. Search by reference to case name. But for other thing, sometimes it's quite difficult. And also, you can search by reference to the name of the court. This one is easy. This one is easy. Okay? For example, if you click Court of Final Appeal, you can find that altogether we have mainly we have 5 types of cases. But when you click Court of Appeal, it's more or less the same. So it's only 6 types of cases. But when you click High Court, what can you find? And you can find so many different kind of case. So many different types of cases. Why? Because in terms of number, the number of cases in the High Court will be much more than the number of cases in either the Court of Final Appeal or Court of Appeal. Because not so many cases will be appealed to the Higher Court. From time to time, when you are reading the newspaper, the litigant will say that they will appeal. But sometimes the lawyer will advise them not to appeal. When the case is not so strong, it will be useless for you to appeal. If you appeal, you incur more legal costs. Many people will give up the idea of appeal to the higher court. Okay? Because sometimes the case is so weak. So it's not meaningful for them to appeal. So the number of appeal case will be much smaller than the case heard in the High Court. So it's the reason why the High Court case is not only classified into civil case or criminal case. It will be divided into different subjects. Some term you may not quite understand. For example, MOT action. What does it mean? I don't know what's meant by MOT action. Does it mean the action in MOT? 係咪喺金鐘嘅案件MOT means shipping. Piece of MOT it means shipping. Okay? And also, for example, so ex parte. Do you know what's meant by ex parte? Ex parte means one party. Usually in the application, you have to invite the other party to attend the application hearing. But in some cases, especially cases relating to infringement of copyright, the application will only be made by one party. Only one party will appear in the application. So it's called ex parte. 即係單方面嘅申請。So the other party will not load the application. Because if he load the application, he will remove those items. So usually it's secret. It will not be known by the other party. Matrimony so usually is divorce. And also probate. To know what's meant by probate. This one probate, probate. So anyone know what's meant by probate? Probate means succession, the procedure. The procedure for succession， OK 因為個will or possession 即係嗰啲遺產承辦So when one person pass away the estate, the money, the asset of that guy will be passed to his successor maybe the family member, the wife, the spouse. The procedure is called probate sometimes quite complicated sometimes it will take a very long time maybe several years before the probate can be finished. I think for other, it may not be so efficient for searching by name or okay. So if you just type Learn Kok Hong, you can find so many cases. Sometimes the item may not be too useful. Search by subject matter is also okay. So for example, if you want to know any case about smoking, you can just type smoking to see whether there's any case relating to smoking. For the report, so we have the generalist report. So it's the authorized Hong Kong law report, and digest is the HKLRD. So it's the most important law report in Hong Kong. The other one is called HKC, Hong Kong cases. And also apart from the generalist law report, we also have the specialist law report. The authorized Hong Kong Court of Final Appeal report, and also Hong Kong Public Law report, Hong Kong Family Law report. So under reported judgment, so you have to understand the the headlock. You have to go through the sample headlock. Okay, I think I will post the headlock of Lai Fun Yung on so you can have a look of the headlock. Usually we start with a catchword, summary of relevant fact or circumstances giving rise to the dispute. From time to time, so please note that before you study law, you always think that in court hearing, the dispute is on the fact. It may not be the case, especially when you're studying law at this stage. So usually the facts are very simple, but the law is very difficult. Number 3, summary of the decision of court and also the principle of law applied by the court is called the holding. And so we have legislation. So for legislation, mainly we have the constitutional instrument. That's the basic law of Hong Kong. So other than that, we have the domestic legislation. Why it's called domestic? Because the basic law was enacted in Beijing. It was not enacted in Hong Kong. So for ordinance and also all the subsidiary legislation, they are called domestic legislation. This one is a very new term because before 1997, we did not have this term. But after 1997, we have to use this term. So to tell you that the law was enacted in Hong Kong. For all the legislation, we have primary domestic legislation. Usually it's called the ordinance. For example, you go to Chapter 622, Company Law. We have the Company Ordinance. Company Ordinance is the primary domestic legislation. But under the Company Ordinance, we have a lot of subordinate legislation. Sometimes it's also called delegated legislation. Sometimes it's called rules, regulation, bylaw, etc. There are so many names for those delegated legislation. In the past, many people will go to the Government Gazette. Government Gazette is published once every week. Nowadays, you don't have to buy a hard copy. You only have to go to the website of the government logistic department okay? So GLS Government Logistics Department 政府物流處嘅網頁you can find the e-gazette nowadays no apart from the hard copy we also have the electronic gazette which is free of charge. Everyone can have access to the government gazette. In the government gazette we have several legal supplements. The first one is about ordinance which is about ordinance passed by the Legislative Council. Supplement number 2 is the subsidiary legislation. So supplement number 3 is the bill. In the past, you have to go to the legal supplement to find the authentic form of the ordinance. But nowadays, because we have the e-legislation. In the past, the legislation in the government website may not be so updated, but now I think it's updated more frequently. For most people, they would just rely on this e-legislation. Not so many people will bother to go to the legal supplement because it's more time consuming. If you want to go to the say legal supplement of the e-gazette, it will be something more difficult. Well, you can go to page 72. You just have a look on the e-gazette. Of course, you can go to the government gazette to find the newly passed ordinance. The website is called GLD, Government Logistic, say Logistic Department, GLD. So it's the Government Logistic Department. You choose the English version. Okay. You can now choose the service to the public. Service to the public. So it's the e-gazette. You choose the English version. Okay. Then you search gazette. You'll find search is very funny. Usually they will give you a disclaimer. You have to. You can choose either one. If you choose I do not accept, okay, you cannot use the service. Okay. So you are forced to accept. So when you accept, you can find the gazette. Okay. So we have different day for the gazette. Usually you have so many gazette. You can choose whichever you want. For example, if you choose this one, we have the government notice, legal supplement number 2, legal supplement number 4. You can choose. You can find this ordinance. Okay, you can find this ordinance. So it's the most authentic text of the ordinance, especially for new ordinance. Okay, but for old ordinance, sometimes they're seldom updated. So it won't be a problem. You go to the e-legislation. I think it will be much more convenient for you to go to the website of the e-legislation. So this one, not so many people will do this one nowadays because it's something very time consuming. Of course, you can have a child at home if you have interest in this method. Okay, lots of one. So we have the e-legislation. Also, apart from the primary source, we also have secondary sources of law, like books, encyclopedia, legal dictionary, glossary, journal, etc. Of course, it depends on how serious you are in the legal study. So, if you are very serious, you can buy more reference book. Okay, that's all for today's lesson. So, in the next lesson, we will go to chapter 5, which is case law. So, I think I already posted a judgment called Yun Set On. So, in the next lesson, please make sure that you have the hard copy of the judgment because we will do an exercise. You have to go through the judgment to see whether you can understand the judgment, and also you have to answer some question. For this judgment. Also, make sure that you have the hard copy of the lecture notes and also the judgment of Mr. Yun Set On. Okay, so I will give you the hard copy. I will post the answer to chapter 1, 2, and 3 to show, so that you can have a look on those answers. So the next lesson so will be this one. This should be Mr. Yun Set On. This one, chapter 5, Yun Set On, judgment. Right? This one, please make sure that you have the hard copy. Okay? Because we will go through the judgment. I will explain the different part of judgment to you, and also I will tell you how to understand a judgment. Okay? This is a very funny case. Make sure that you have the hard copy. Okay? Thank you very much for attending the lesson. So see you on Thursday. So now Hawaii, as what I have mentioned, so the ex parte application is secret. So you will never notify the defendant. Thank you very much. So please send me the question by email. So for the law report, I think you have to pay subscription. So no, you can. It's not free of charge. Because it's provided by Lexis. You have to know that they are money-making body. Some law firms have subscribed the service. If you work in a law firm, you can have access to Lexis, or you can go to law library. Assignment. Oh, I don't know. Assignment revision. Do you mean the revision seminar or assignment revision? Check Michael. Michael check. You got an email yesterday about assignment revision. So what does it mean? I think it's not assignment revision. It means assignment workshop. There's a workshop for writing assignment. The lecture will no, it's not. No, I'm not teaching for this seminar. It should be by another lecturer. Okay. He will tell you how to do an assignment. I think that I'll load it to do anything. So he will give you a handout in the seminar. Maybe sometimes I don't know whether it's some typing mistake. I think Hilda, you say HKLII. HKLII may not be so useful now. So for this one, you can also find the e-legislation. I think you better go to the website of e-legislation. So for this one, I think it's not too useful. But this one is international. It means that it's not only in Hong Kong, but also in other country like UK or Ireland or some other country. You want to have some idea about the law of other country, I think you can use this one. Okay, thank you very much for coming. Very good. Okay, so we'll end the meeting now.